Can legally prescribed marijuana be used in a custody battle? Let's assume we have a case of one parent using marijuana for medical reasons, back pain, anxiety, things like that, and allergic to all other prescribed medications that would kill the pain. And then we have the other parent, the custodial parent, who says, well, this parent is impaired and therefore the visitation should be supervised forever unless this parent stops consuming marijuana. And as we know, California is a state where marijuana is legally acceptable and can be prescribed, and therefore it's okay to take marijuana for many reasons. The court would look at many factors. Number one, THC level. Can THC level be determined in blood, for example, like it would be in blood alcohol concentration? No. No doctor can prescribe and say, well, at this level of THC level in your blood, you're not impaired, but at this level, you're impaired. No doctor will do that. No doctor licensed in California will do that. There are other states where there is some discussion about at what point impairment starts, but it's a common knowledge that marijuana can stain blood after one person consumed it for days or weeks. So even though the impairment is no longer there, so THC would be high, although the consumption was 2 weeks ago, for example. So the court has to look at other factors. Okay, THC is not a factor. Impairment. How is the parent who consumes marijuana behaves in front of a child? And depending on the dosage, in some cases it can be an issue, but in most cases when it's prescribed and taken for medical reasons, the parent is not impaired.
I created this book to help you understand the divorce process without getting lost or without getting a heart attack. You can buy it on Amazon in all formats, including audio format.
So the court has to look also at the Family Code section 3020, where a child has to have continuous and constant contact to both parents. So we're looking at potential impairment, not actual impairment, and one parent is trying to take away parental rights from the other parent and from the child to have connection based on alleged impairment. So it's a factual determination if the parent who is consuming is impaired or not. This is something I would look for. There is one case, Drake from 2012, that says a court cannot, just by the fact that one parent consumes marijuana, restrict custody rights unless there is proof that that parent is impaired. So basically, what court will do is this. The court will set the parent who is consuming marijuana to potentially, if they do that, would mean that they have other drug-related issues. If this is an allegation, overall allegation, that parent takes not only marijuana, but cocaine and heroin and things like that, or alcohol, then the court will set an order that requires the consuming parent to undergo urine random weekly observed full panel testing. Not forever, but for quite some time. Follicle test, the court has no authority to order, so it would be voluntary if there are other drugs involved. And the court might say, if there is enough evidence that impairment happened in the past, the court might say, well, let's supervise the visits for a while, maybe for a month or 2 or 3, and then if everything is fine and the THC level continues to be similarly the same and nothing happens, then we will lift the supervision and move on to a normal schedule. So what is the takeaway? The takeaway from this, if I were to represent the parent who is medically consuming marijuana, I would point out the fact that that parent is not impaired by the fact that they're consuming. And if I were representing the other parent, I would be gathering evidence, pictures, text messages, behavioral glitches to say that parent is impaired. So it comes down to a factual determination of impairment. Because right now in California, we don't have blood alcohol, THC level that can be set to restrict and say, at this point, this person is impaired. So anyway, I hope that was helpful, and I will see you in my next video. Bye.